Hello. Thank you for allowing me to take your deposition, Dr. Hansen.
As if I had a choice.
You are a medical examiner, correct?
You already know that I am. Can we cut to the chase? I have important work to do.
And did you perform an examination on Mr. John Smith in February of 2010?
That is why we are here.
Now, was Mr. Smith deceased when you did your examination?
I am a medical examiner. What do you think?
What I think is not relevant, and I do not need to disclose that information as it is protected under the work product doctrine.
How about whether you have the ability to think? Would that be relevant?
So was Mr. Smith deceased when you examined him, or not?
I will try to use small words so you can be sure to understand. I am a medical examiner. I am not called to examine a person unless the person is dead.
So you admit that you are familiar with performing examinations on deceased people?
You are an idiot. All of my examinations are on deceased people.
I did not ask whether I was an idiot. I will let the jury decide that for themselves. I asked if you are familiar with performing examinations on deceased people, and you are, correct?
Does this answer your question?
Let the record reflect that Dr. Hansen has motioned to me with his middle finger to signal his dislike for my questioning. I move to strike the indication on the record that Dr. Hansen has motioned to me with his middle finger.
Is there any more questions for me, or can I return to doing something important?
So how did you know Mr. Smith was deceased when you examined him?
Because Mr. Smith did not have a pulse and his brain was sitting in a jar next to my scale.
So how did you know Mr. Smith was deceased?
Did you actually pass the bar exam? I am shocked the state gave you a license to practice law.
So how do you know Mr. Smith was deceased?
You are right. Perhaps he was just sleepy. Is your client at all aware of your ineptitude?
Aha. So Mr. Smith could have been alive.
Yes, I suppose he could still be alive and practicing law at your firm.